The reference is motion on impeachment of the governor of Muranga County. At page 17, my lord, the speaker informs the governor, page 17, that the governor has 7 days to respond to that motion. 7 days, my lord, was last yesterday. My lord, between the 15th, there was an intervening weekend. So the governor had 1 day, or within 1 day, my lord, at page 20, wrote to the Speaker of the Assembly on the matter of the proposed impeachment of the governor. Material, my lord, to this matter is page 26. The paragraph in the middle that starts as such, my lord, the page 26 is the letter. There is a paragraph where the governor is telling the Speaker that as such, in order to enable us to substantively respond, we request for further particulars and documents showing the governor's direct and personal liability on the matter that forms the basis of the alleged violation. By the office of the Speaker on Monday the 19th. Mark you, my lord, between the date, the month, within 1 day, excluding the at this point. My lord, yes. And before even the 7 days the Speaker gave, so we have seen the Speaker gave 7 days. So before the 7 days, my lord, the Speaker gave, on the 21st, the day before yesterday, the motion was moved to adopt the motion for proposed removal of the governor was passed by the Assembly. And at this point, allow me to refer you to the standing orders of the Assembly at page 34. Where this note is important is this: we shall accord you a right to be heard. It is in black and white in the letter. This is in consonance with the standing orders at page 34. Now, if you go to page 34, I've attached you for your ease of reference for proposed removal of a person from office. This is what the standing order says. That whenever the constitution or any law, petition or proposal for the removal of a person from office, the person shall be entitled to appear before the relevant committee of the Assembly considering the matter and shall be entitled to legal representation. Was moved. The Assembly's own standing orders gives the governor a right to appear. The governor was denied that chance. And like you've seen, my lord, on the 19th was on a Monday. 20th was a public holiday. The motion was moved on 21st. So there was never, at any one time, an invitation to appear before a select committee of the Assembly or the Assembly in plenary. What's the law regarding that issue? Bulky decision, so I thought perhaps it would be easy for my submission just to attach some excerpts. This is the Wambora decision, the one that was had in Kerogoya by 3 judges. And they were unanimous at page 52. It was the same scenario. The circumstances were paramaterial with the circumstances that faces the governor of Muranga. And this is what your lordship, it is at the county assembly that adverse findings against the conduct first made. And it is those findings in the form of a resolution that outcome may affect his political rights to hold elective office. We are persuaded to find, which we hereby do, that even at the county assembly, the right to a hearing must, the words your lordship ordered to a governor, at any one time, that the motion proposing removal from office is being debated before it is approved by the judge. So that right is mandatory. And the county assembly cannot trash that requirement. In fact, it has made provision for that requirement in its own standing orders. Our submission, my lord, is this: that to the extent that that right was denied, there cannot be a valid resolution that can emanate from the assembly that is capable of being transmitted to the Senate for the Senate to act upon. Because the substratum is unconstitutional. My lord, these are issues because whatever the assembly did was quasi-judicial in nature. So regardless of whatever may happen in the Senate, if the substratum is unconstitutional, there cannot be any valid proceedings that can be.
Now, that time with the Senate, that's all I want to see. If it's before the Senate, there may be prejudice, but I'm talking about now, what's the problem? Where's the prejudice? If the Senate that was making this determination, I would be worried if they had proceeded the way the county assembly has proceeded. It doesn't have all this. When all these proceedings are before the Senate should be able to see you have never had the chance to address all this. Isn't that correct?
I do agree that it is open. It's also correct, my lord, that where you're saying that your rights have been trampled upon, I mean, as a citizen of this country, and you're saying that, look, there is an action here, and like you have seen what their lordship said, is that the proposal is likely to lead to an adverse finding. That is what the judges in the Mwangi division said about giving the governor an opportunity, because you're now subjecting the governor to a process that may not even have led there had he been given that chance. So that, my lord, we are inviting the intervention of the court at this stage before even the matter gets.
You know, it all went to the Court of Appeal, and ultimately Wabora was back as the governor. So I'm trying to see the prejudice, and that's what I'm not seeing. At this stage, I need to be satisfied that there will be ultimate prejudice. That is what I need to be satisfied. They are not here. You argued as if the other side was here. But at this stage, what you should be focusing on is to demonstrate to me the prejudice.
Not the prejudice.
Where is the prejudice? The Senate is going to give him a hearing. We are not saying, not had you say the Senate is indicated they're not going to give Governor Mwangi, Iria a hearing. So where is the prejudice? He is entitled to raise all this before the Senate.
Yes, but this is a point